Hi madam, I'm Shelina. For our group assignment in the subject of industrial relation and employment law, we choose the cases. These are my group members, Venisha, Sembai, Kangeswari, Saraswati, and I, Shelina.
Good morning, madam. My name is Vinisha Arjunan. My metric number is 4232008881. We are from Group 4. I am going to present the summary of this case. The case title is Thavaneswaran Analalaki Mutaya versus MyJet Express Airlines Centurion Berhad. This case involves Thavaneswaran Analalaki Mutaya, a former employee of MyJet Express Airlines Centurion Berhad, who was dismissed on January 31, 2023 through a retrenchment notice. The company claimed financial difficulties due to the mismanagement, leading to the termination of approximately 70 employees, including the claimant. The case was brought to the Industrial Court of Malaysia, but the company failed to attend hearings or provide any evidence to justify the retrenchment. As a result, the court proceeded ex parte, meaning it only considered the claimant's evidence. The court ruled that the company failed to prove financial distress and did not provide valid reason for retrenchment. Therefore, the dismissal was deemed unfair and without just cause or excuse. Since the claimant was not reinstated due to reaching retirement age 60, the court awarded financial compensation. The first one is back wages 405,000 ringgit, 20 months salary. Second one is annual leave balance 47,076 ringgit and 90 cent. Third one is extra flying hours 5,990 ringgit, and the total compensation is 458,066 ringgit and 90 cent. The company was ordered to pay within 30 days. In conclusion, this case highlights the importance of employer participation in legal disputes and reinforces the retrenchment must be justified with credible evidence. The court upheld employee rights, ensuring fairness in industrial relation. That's all from me, madam. Thank you.
Hi everyone, I am Sembai Surbayan from B875. My metric number is 4232004791D. Today I want to talk about three issues about this case. First, MyJet Express Airlines terminated Thavaneswaran Analaki Mutaya and 70 other employees on January 31st, 2023, citing financial difficulties due to mismanagement. However, the industrial court found that the company failed to provide any financial records or supporting documents to justify the retrenchment. Since employees must prove that layoffs are conducted in good faith, the court ruled that the termination was unfair. Additionally, the claimant was out unpaid wages, flying allowance and leave payout, which the company did not dispute. Secondly, a major prudential issue in this case was the company's complete absence from the court proceeding. Despite multiple hearing notices, MyJet Express Airlines did not attend or submit any defences. As a result, the court proceeded with an ex parte hearing where only the claimant's evidence was considered. Legal precedents such as Gun Kui Pui, VJP courts, and STPHD emphasize that employees must justify dismissal, but in this case, the company forfeit its right to defend itself. Lastly, the court ruled that the termination was unjustified and awarded that claimant RM 458,066.90 cent in compensation, including back pay, unpaid allowance, and leave payout. Since the claimant had reached retirement age, resistment was not an option. This case highlights the importance of due processing in detachment, requiring employers to provide clear evidence for layoff and actively participate in legal proceedings to avoid severe financial and reputational consequences. That's all from me. Thank you.
Hi everyone, today I will be discussing the legal aspect of the case Thavaneswaran and Mutaya versus MyJet Express Airlines Indian Berhad and how it relates to nation employment law. This case falls under the Industrial Relation Act 1967 IRA 1967, specifically Section 20 Clause 3, which protects employees from unfair dismissal. Tavaneshwaran was retrenched on 31st January 2023, but the employer failed to provide valid proof of financial distress. Since the company did not attend court hearings, the industrial court proceeded ex parte under Section 29 Clause D of the IRA 1967. The burden of proof was on the employer to justify the dismissal, as seen in the Stamford Executive Center versus Pondashini Ganesan case. However, no evidence was presented leading the court to rule the retrenchment unjustified. As a result, the court awarded Thavaneshwaran 458,066 ringgit 90 cent in back wages and unpaid entitlements under Section 30 Clause 5 of the IRA 1967, which ensure decisions are made based on equity and good conscience. However, since he had reached retirement age, he was not entitled to reinstatement based on Sabah Forest Industry Sdn Berhad versus Industrial Court Malaysia and Anna. This case highlights the importance of following proper retrenchment procedure and ensuring that dismissals are justified with clear evidence. Employer must comply with employment laws to avoid legal consequences.
Thanks, Kanageshwari, for your part. Hi, madam, I'm Shelina, and I'm going to present my part on the comments regarding the Thavaneswaran case. The first, I'm going to present about pros of the case. Protection of employee rights, which means ensures employees are not dismissed unfairly without valid justification, strengthens legal protection for workers against wrongful termination. The second, legal precedents for fair dismiss. Employers must justify retrenchments with solid proof, prevent misuse of financial distress claimed to lay off workers unfairly. The third, compensation for affected employees. Employee awarded RM 458,066 and 90 cents as financial relief. Encourage fair compensation in labor disputes. The third, judicial fairness and due process. Court follow proper legal procedures even without employee participation, reinforce trust in Malaysia labor law. The last encourages transparent HR practices. Business must document employment records properly, helps prevent future legal disputes and wrongful termination. In the comments on the case, I'm going to present the part 2 cons of the case. The first, employees non participation, which means the company did not attend court proceedings, results in one side ruling favoring the employee. Second, lack of financial proof from employer. Employer claimed financial struggles but provided no evidence. Court had to rule based only on employees' claim. The third, financial burden on business, which means larger compensation payout can financially impact struggling companies. Small and medium-sized enterprises may struggle to afford penalties. The last, lengthy legal process. The case took almost 2 years to resolve. Delay in justice affects both employees and business. In the conclusions of the comments on the cases are the first protects employees' rights but also increases employee responsibilities. The second emphasizes importance of due process in judgments. The third, companies must follow proper procedures to avoid legal risk. The last, need for faster dispute resolution to avoid lengthy
My name is Saraswati Mahindran and my trade number is 4242 000 141. Today discussing key solutions to prevent retrenchment disputes in organization. Retrenchment can be a sensitive and legally complex issue, so implementing fair policies and enforcement mechanisms is crucial. First, companies must establish clear retrenchment policy in compliance with the Employment Act 1955, Section 12. Employer should provide valid financial evidence, such as financial reports or audit statements, before initiating retrenchment. Additionally, the last in, first out, LIFO principle should be followed for ensure fairness and retrenched employer should receive proper severance package and job assistance. Next is legal enforcement must be strengthened to prevent companies from exploiting loopholes. Harsher penalties such as fines, blacklisting, and legal consequences should be imposed on companies that ignore industrial code orders. Moreover, monitoring units should be established to ensure companies comply with court decision and provide new compensation without unnecessary delays. Another key solution is to establish an employer compensation protection fund to support workers facing unjust retrenchment. This fund acts as a financial safety net for employees who are unfairly dismissed or whose employers fail to pay compensation. The fund should be financed through employer contributions and government allocations, ensuring that affected employees receive immediate relief while the government takes legal action against defaulting employers. Mediation is an effective way to reduce unnecessary job losses. Before layoffs, employers should consider alternative solutions such as unpaid leave, shorter work weeks, or voluntary retirement schemes. Companies should also be required to consult trade unions or mediators before making retrenchment decisions to ensure fairness and transparency. Finally, improving communication between employers and employees can prevent misunderstanding and disputes. Companies should conduct regular financial updates, town halls, and open forum to keep employees informed about potential retrenchment risk. Additionally, organizations should provide severance package, job referrals, and mental health support to help retrenchment employees transition smoothly. Thank you.